1997-481. Looks like we have Mr. Thomas for the defense.
That's correct, John.
Tapp is here as well. Mr. Neufeld is here for the defense. We have Mr. Clark for the state, and I forgot your name.
Mr. Dewey, Your Honor.
Mr. Dewey, sorry, I apologize. Okay, well, we're scheduled today for a status conference. I notice that there is a possible stipulation that's going to be discussed today. Is that correct?
That's correct, Your Honor. I think we discussed me placing just generally that on the record pursuant to that stipulation.
If you'd like to state that, that'd be fine.
Thank you. As the court's familiar, Your Honor, we have a continuing obligation under Rule 16A as well as under our ethical rules 3.8G to provide to the defense any exculpatory or potentially exculpatory information on an ongoing case. As the court's aware, there's new evidence that's come forward. It is in the state's possession. Understandably, Mr. Tapp's legal team would like possession of that. At the same time, we want to comply with that rule. We want to balance Mr. Dripps's right to a fair trial. So the stipulation that's proposed to the court is that we provide unredacted information of all of those things, specifically the information that's come to light in 2019. Provide that to the defense under a protective order by this court, and then if there is a request for dissemination beyond to Tapp's legal team, I believe we would either stipulate to that or bring that issue back before the court.
That sound correct, Mr. Thomas?
Yes, sir.
Well, if that sounds reasonable to the court, so if you'll provide the appropriate order to the clerk, I'll view it in my queue and I'll sign that as soon as it's provided.
Very good, Your Honor.
Anything else that we need to discuss today?
Yes, Your Honor, if I could, Mr. Tapp would just like to express his frustration as well as his gratitude for what's going on today. Mr. Clark has indicated that he has, under the Idaho Rules of Professional Conduct and Duty, under 3.8, it says that the prosecutor in a criminal case shall, and it goes on to list several things that they shall do, one being not prosecute a case they don't believe has probable cause to go forward. And there are other things, but under G, it says when a prosecutor knows of new, credible material evidence creating a reasonable likelihood that a convicted defendant did not commit an offense of which the defendant was convicted, the prosecutor shall promptly disclose that evidence to an appropriate court or authority and promptly disclose the evidence to the defendant unless the court authorizes a delay. So I think that's partly why we came before the court for the status conference today. The state needed to present the evidence to the court in Mr. Tapp's case, which is different than Mr. Dripps's case. And so we believe that under Rule 3.8G, we are entitled to that information. The state has agreed to turn that over. So we're also going to move, hopefully, in the next few weeks, to exonerate Mr. Tapp based on newly discovered evidence and the evidence that we have already. So we have DNA evidence that the state has tested. They've tested semen left on the body of Angie Dodge. They've tested all the clothing that Angie Dodge was wearing the night that she was murdered. They tested a teddy bear that was in the room that she was killed in. They tested a blanket. They tested hairs found on Ms. Dodge. They've gotten skin cells from Angie Dodge's hands. And all of these things lead to one perpetrator. And 2 years ago, we knew all this information, but we didn't know who that perpetrator was. 2 years ago, we were litigating a false confession. We've litigated the interrogation tapes of Mr. Tapp. We know that Mr. Tapp was a victim of police interrogation tactics, and he gave a false confession. We know that now. And now, thanks to Carol Dodge, the Idaho Falls Police Department got CeCe Moore involved, and through her work with genetic genealogy, she was able to find the killer of Angie Dodge, who we think is the killer of Angie Dodge. And on May 16th, 2019, in a very dramatic fashion, they held a press conference. They told the world that they had the DNA match of who they believe the killer of Angie Dodge was. And so we're getting the evidence that the state has turned over to the Mr. Dripps' attorney, and that's what we're asking for, and they've agreed to do that. And so we're just fulfilling the special responsibilities under the rules of professional conduct, Rule 3.8G, in the hopes that they will, under Rule 3.8H, remedy the conviction of Mr. Tapp. We believe that Mr. Tapp is actually innocent of this horrible crime, and there's an expectation from everyone, I think, that there will be a resolution to this on July 17th. We would ask the court, if the court is willing, to set a court hearing on July 17th.
If I may refer briefly on it.
You may.
Thank you. First of all, thank you very much for permitting me to appear today. I'm from New York City. I'm the co-founder of the Innocence Project and the special counsel. We do not get any of the credit for the incredible work that's been done on behalf of Chris Tapp, nor do we deserve it. Mr. Thomas has represented him incredibly well for a number of years. Greg Hampikian, the Idaho Innocence Project, has represented him incredibly for a number of years. There are two appellate attorneys who did wonderful work on his behalf. But we've been asked to come in for the last mile, for the last lap, to make sure that things are done in a way that really speak to what Chris is entitled to, and we're happy to oblige. There's no question, you know, that Angie Dodge was a victim in this case, and it's just an unspeakable crime. And her mother Carol and Angie's three brothers were all victims. But I don't want anyone to lose sight of the fact that Chris Tapp is a victim also, and has been a victim for 22 years and 6 months. And we sometimes forget that it's not just Chris Tapp. But I had the pleasure of meeting Chris's mother, Vera, who's here today, and she's a victim. And all the members of Chris's family are victims as well for what they've had to endure. We are very pleased that we have been assured by the district attorney in a meeting here this morning that it is their expectation that this matter will be wrapped up in 2 weeks on July 17th in a way that we find appropriate and helpful to Chris Tapp. And that's why you know, we're okay waiting for that. My co-counsel mentioned the frustration, and of course it is palpable. If you've suffered that long, if you've had that cloud hanging over your head for so long, you want it removed so you can restore your own character and reputation in the community. And also, we often think about the whole question of justice being delayed is justice denied. But we're confident, after speaking with the district attorney this morning and the deputy, that they intend to move with all deliberate speed and wrap this thing up on the 17th. And with your permission, I'll be back here on that day to join Mr. Thomas and Mr. Tapp.
Okay, thank you.
Thank you.
So, Mr. Clark, is the 17th an appropriate date to set another hearing in this case?
I think so, Your Honor. Right? You know, I appreciate counsel's comments in this regard. I want to make sure I'm going to speak very generically to anything that's currently ongoing now, because we've got an obligation to continue to ensure a fair trial to Mr. Dripps. So I don't want to get into any of those specifics. However, what I have seen with what I think is a new and reinvigorated investigation by the police department, you know, if there was ever a case that speaks for the proposition that when a defendant or when a suspect makes a statement, the police ought to make an effort to verify or check the veracity of those statements, this case is certainly that, or rather the Dodge case. Those things have been done by full-time dedicated detectives on the case, as well as individuals from my office, to get that to a conclusion. It seems appropriate to me that if I am going to get to a point where I'm going to make a decision on this case, it should be done when that's completed. We've been working with the police department in that regard nonstop since this case broke a few weeks back. I've been in communication with the chief of police, who indicates that a couple of weeks should satisfy that. I appreciate the patience by Mr. Tapp and their legal team to give us this time. It seems appropriate And if the police want that additional time, that occur. And that's been our intention throughout. I want to also note, Your Honor, we brought to Mr. Tapp's team this information generally, the day after this case broke. Certainly they're entitled to these specific documents for themselves, and that's part of what's going on today. But based upon our discussion over the last couple of weeks, I think that the 17th is an appropriate time frame, best I can guess right now, yes. And we do anticipate coming to a conclusion at that point.
Okay, well, we'll reschedule this matter then for 1 o'clock on the 17th of July.
No, Chris is innocent, and we're looking to exonerate him on July 17th. Everybody show up, and hopefully we'll have a great celebration.
I know a lot of people were hoping for that today, the Idaho Innocence Project. You even had counsel from New York.
Right. It just didn't happen. It's just one of those things where things got delayed, and people, there are just things they need to shore up, and we're okay with that.
So once he's exonerated, let's say on July 17th, what's the next step after that?
Chris Tapp looks for a job. He's going to look for a better job, better paying job. Anybody who's out there willing to hire him, please do so. Call us, call Chris, call our office. We'll get you hooked up. But he's certainly somebody who is looking to get this murder case behind him and get fully exonerated as he's innocent. So.